Okay, you live. I'm about to make it a post.
All right. Okay. Peace, power, and profit. We are back again with another studious live stream. And today we're going to talk about some investment recommendations and estate planning. Basically, try to cover uh, those of you that have families who are married with children and some type of dependent, so forth and so on. So what we're going to start with is a basically trying to help you build a profile, a financial profile for yourself. So, and this could be an individual as well. You don't have to be married or so forth and so on, but it does kind of require you to have some type of beneficiary, whether it's a family member or somebody you're close to that you trust, and so forth and so on the behalf of you as a person. If something were to happen to you, you know, whatever that you have, whether it's assets or bank account, so forth and so on, it can go to somebody that's close to you or a beneficiary. All right, so um, if you've never been to a firm and you really don't have a financial advisor, seeing over your assets, um, they typically will kind of build like a financial profile to um, kind of put you where you need to be as far as the accounts you need and all of that stuff. So, um, of course, you have like individual accounts, and then you have other accounts that are for, like I said, beneficiaries. If you're married, there's joint accounts, and that's what we're going to start with right now. So, just going to read some material, some of the stuff you can find on your own. I'll make sure to share what I have, or have Mo put that in the chat here in a little while. But I want to start out by reading basically what an individual account is. Basically where a single person wishes to open an account for his or her benefit. Um, and you don't really need any special paperwork. It's no different than opening a bank account. You just need, the basic stuff. Um, and then you have the individual account, or a TOD or POD, because a lot of times, like I said earlier, is when you have your personal individual account and you don't really set it up to give to a beneficiary, so to speak, um, it could be a problem. So a problem with an individual account is that when the owner dies, the account gets locked up until it goes through the deceased individual's estate. And so we'll talk about, estate and estate planning and wills and all that stuff later. Um, Hopefully we get time to get there. But I just want to kind of run through this real quick, because I know in our community that this type of information is lacking, and a lot of times we leave what we have or what we own and nobody gets it. So this is why this stuff is important. This is why it's called investment recommendations. All right. So um, a problem within an individual account is that when an owner dies, the account gets locked up until it goes through the deceased individual's estate, and it must go through probate, where anyone can contest the will. So that's basically when you go to court. Anybody can claim it. They can be like, oh, well, blah, 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 left it to me. And it could be a whole debate, and you got to go to court to have those proceedings. Something similar is kind of like what OJ is going through currently, with his estate. And it's a lot more complicated than that. But if you don't have a beneficiary, basically anybody can claim, whatever you left. So that's why it's important to have a beneficiary or somebody you trust with whatever you own or have. Okay, so it says here, most states now allow an individual to be held TOD, which is a transfer on death. Transfer on death, also called pay on death, POD. TOD registration allows the customer to maintain control over the account, but upon death, the account assets transfer to the named beneficiary, bypassing the estate and bypassing probate. No one can contest the transfer. So that's why it's good to have a beneficiary on file with, your broker, your advisor, so forth and so on. That way, nobody can come out of the blue and contest that, oh, he owed me this, he told me this and that. Well, no, the paperwork said that this is his beneficiary and it belongs to them. Then you have no debates. And a lot of times, you even see it with, celebrities. A lot of times they don't have a will, they don't have a trust, they don't have an estate, and people can come, family members, don't matter if you ain't seen them since you were little, they can just come in and make a case on why they should have that. And when you don't plan for this type of stuff, it can be messy like this. So that's why it's good to know this information so we can pass it down to the beneficiaries, and we don't have to do all the drama and waste a bunch of time, sometimes resources, to get our claim, so to speak. And it just puts your life in order. It gives you some stability. Um, and everybody kind of knows, the people who need to know, kind of knows the order of business, how this works, and can keep your legacy and what you want to happen with your estate or with your assets or whatever it is, how you want that distributed. So we'll get into more details later if I can cover all of this tonight. But this is kind of like the basics. Um, let's see. All right, TOD registration is often used by an elderly parent that wishes to have assets passed directly to an adult child upon the elderly owner's death, and is often used in second marriages where there are children from the first marriage, and each spouse wants to make sure that his or her assets go only to his or her respective children upon death. All right. So you have, some people out there that, they make kids with, a first marriage, and then that marriage doesn't work out, and then they remarry, and so forth and so on. So you want to make sure, your seeds are covered, and give them like an inheritance, which our people needs to do more of. Um, so everybody gets a piece of your legacy. Legacy is important. So we have to, whatever we're building here during our lifetime, and if you have assets, you have something that's, has some value, that's worth something. It doesn't matter if it's a leather couch or, a photo album from, the 1800s. If it's labeled value, you want to make sure you put that in there. That way, it's protected, and you put it in good hands, and that's about all you can do. But if it's worth something, you should have that in a trust or a estate or will or whatever the case is. And that's all of this. All what this is saying is that you need to make sure you pass that legacy down, and don't just die and you got all of this stuff and nobody really cares to take care of it, or only one person finds it valuable. So don't you know establish your legacy and pass your legacy down to keep it flowing, keep it rolling. And that's what a lot of our people uh they don't do. We don't pass down our legacy or things we own and value. It's got to be more than word of mouth. It's got to be documented. It's got to be on paper, and that's putting things into uh or giving it structure, I should say. Putting this stuff in a document on paper, legalized. That way, you know, nobody is arguing or bickering about, you know, who deserves what. I did this for this person, and sister, this and that. They owe me. They owe me for this, and we can shut all that down by getting this stuff put on paper and documented. Like, this is where my legacy is going. This is who I want to run this. This is this person's portion, and so forth and so on. We just cut all the drama out and nip everything in the bud, but we make sure that the legacy lives on, and the beneficiaries of that can keep the legacy living on strong and doing the right things with it. All right, so now we got something called a Totten Trust, uh, um, which is a TOD registration, which is the transfer on death. Um, it's not really a trust account. Let's read here. This is not really a trust account since any adult can open one without a trust document. These are usually small bank accounts where a beneficiary is named to receive the account balance at the depositor's death. Often the beneficiary does not even know of the existence of the account. The depositor can revoke the Titan trust at any time without penalty. So, um, at some rare occasion that there's an account you don't know of, and they created a Titan trust, um, that's what that is for. I'm pretty sure, people have done it, but I'm not sure it's that popular. Yet and still, this is another thing or another account that, parents, grandparents can create and, make sure that, the kids are taken care of, you taken care of, and all of that. All right. So moving on, let's go into joint accounts. So we kind of know, what a joint account is. It's you and another person, maybe your significant other or brother, sister, cousin, best friend, colleague, whatever. So basically, it's more than one person. So with this account, to open such an account, a signed joint account agreement is needed, signed by each named person on the account. So y'all document this, right? And it goes right back to paperwork, getting everything on paper, getting your signature. So you're liable for anything. You can't say, oh, well, my name wasn't on the account anyway. So, nah. It's got to be on legal paper. So everybody is in agreement. Everybody knows what's going on, so forth and so on. All right. So in that joint account, there is something called joint tenants with rights of survivorship. And that is each party owns an undivided interest in the account. If one party dies, the other person is the sole owner of the account. This ownership option is most common for a husband and wife. Note that it can also be used by two people who are unmarried living in a committed relationship or similar family type relationships. So, simple and plain, y'all both got to sign the document. Um, it can be family members, it can be husband and wife, it can be, boyfriend and girlfriend that's committed, but it's an account for more than one person. But again, it's documented. Uh, Mo, give me 1 second. Okay,
Chris, did you
sorry.
go on mute?
Yeah, I had
Oh,
to take a call. All right.
okay.
Yeah. All right. So now, since we got that out the way, there's another joint account called tenants by entireties. This is a method of joint ownership that is only available to a married couple and which is only available in a limited number of states. So joints, like joints of tenants with rights of survivorship, if one dies, the surviving spouse becomes the sole owner of the property. The main difference between joints with tenants with rights of survivorship and tenants by entireties is what happens if one account owners is sued. Tenants by entireties treats the ownership of the account as one entity. So remember, the joints with rights of survivorship, it's multiple entities, but within tenants by entireties, it's one sole entity. So that's why it's primarily beneficial for just a married couple, not friends and family members and business partners and all of that other stuff. So if um if you get sued, the the owner, both of y'all are getting sued. So okay, going on. Tenants by entirety treats the ownership of the account as one entity. And if one of the owners is sued and a judgment is obtained, the assets in the account cannot be seized. In contrast, with joint tenants with rights of survivorship, the joint tenants are not considered to be a single legal entity. If a single spouse was sued and a judgment was obtained, the creditor could get 50% of the assets in the account if the judgment was that large. So these are the main differences between the two. But the tenants of entireties is basically only available to married couples. All right. So the next joint account we have is tenants in common. With the tenants in common, each party specifies a percentage interest in the account. If a person dies, his percentage interest is included in his estate. It can then be passed by will to any named person. This ownership option is most common for business partners. So as you can see, each account has specifics for the people that are creating the account. So you had a regular individual account, then you have a regular joint account, and then you have a joint with rights of survivorship, and then you have the joints with rights of survivorship. Basically, married, boyfriend and girlfriend, cousins, other family members, so forth and so on. And then you have uh, tenants by entireties, which is strictly for married couples. And now you have tenants in common, which is, for business partners, because of the percentage of interest that each will have in their account. So if it's just two of y'all, then y'all are 50-50 partners, basically, in this account. And like it says, if that person passes, it goes to his estate, and then a decision to be made on where um, that ownership goes after that. So it's common for business partners to have this type of account. Next, we have um, family limited partnership account. Limited partnerships are business forms that allow for flow through of gain and loss to the partners without the business itself being taxable. The family members are the partners in the venture. These are used for estate tax planning purposes, where typically the parents are the general partners who contribute assets to a trust over which they maintain control. The heirs, which are the children, are the limited partners who have no management role. They are the passive investors. The parents use their estate tax credit so that no estate tax is due when the assets are contributed to the trust, and the value of such assets contributed to the trust is discounted since these assets are worth a lesser amount when they are held via a limited partnership or partnership assets or illiquid. So you have the parents who are the general partners, and then you have the children, which are the limited partners. And the business itself is taxable, but the limited partners, just like a LLC, uh, which is limited liability. I know a lot of people are familiar with that. So the children in this regard, they are the limited partners. They have no management role. So the parents are the bosses, so to speak. And then I think right down here is going to talk about um, how that is going to work when it's passed on. So they give an example. So the parents might contribute a $700,000 house to the trust, but it goes into the trust at a $600,000 value against the estate tax credit, because you got to pay the taxes. This discount is one tax benefit. The next benefit is that each parent then gives $16,000 worth of their shares each year to each child. Up to $16,000 of gift can be given. This was in 2022 to a recipient without the donor having to pay gift tax. Note that this amount is adjusted for inflation annually. Thus, over time, the asset in the trust becomes the property of the children without an estate tax bill. So this would be good for that family or that legacy that we were talking about, because now we're taking advantage of a taxable event for something like a house, and then you just pass those shares and you gifting it to the trust for the children, and it's not taxed on the donors of that. So this is, very beneficial, man, for families that, they have a family owned business or whatever the case, or, they've been gifted something, down the line, and then they want to pass it down, to, the next generation or the kids, and then the kids pass it down to their kids, and so forth and so on. So you keep that value and hold the legacy together. Um, and so like that's a family limited partnership account. that you can get, and it goes on to say to open such account, a copy of the certificate of limited partnership, the document filed with the state to create the legal partnership entity must be obtained. I think you can set this up as hold on. It says institutional customers are broken down into two broad categories. The oldest form of institutional ownership is either a sole proprietorship or a general partnership. These business forms predated the invention of the corporation, which happened around the year 1600. With these older business forms, you simply go into business. Yeah, so that's basically what a sole proprietorship is. Um, the state can ask to be notified that you are doing business there, but there is no state creation of the business itself. Um, both sole proprietorships and general partnerships are the easiest businesses to form, but the owners take on unlimited liability. I think we all know that. In contrast, state-created business entities limit liability, which is their major benefit. So that's the family limited partnership account. Um, hopefully, we have some people out there that are already doing this, but it is another account that you can definitely use and put it to work, man, for your family. So this stuff is all about family and passing down your legacy and making sure everything has paperwork. We can't just talk. It can't just be oral and verbal. We got to put this stuff down on paperwork, make it legal, make it real. It can't just be an idea. It has to be real. And we have to be honest, uh, this is severely lacking in our community. This will get rid of, GoFundMe's and, a bunch of cash apps and all of this other stuff. But, you can create an account, start putting money into that account or whatever it is that you have a value in that account. And a lot of times people put appreciated assets in that account, because they're going to hold their value. And it's something that, the younger generations can, benefit from because it's the legacy. The legacy is important. A lot of times we like to talk about, our ancestors' legacy with, people discussing, African history, talking about the pyramids and, the different things the different cultures held in regard as far as, spiritual systems and, mask and art and stuff like that. It's the same thing with this. We got to be able to pass down our legacy, and our culture of building, good habits with finances and entrusting those to the kids or to the children to do the right thing on what we're building now. This is how you have an empire. This is how you have a legacy. But it has to start with you, and it has to start with legal documents being written down. And it's, just think about that. It starts with you. So if you're a parent, if you're a grandparent, or if you just single, get you an account, man. Get you an account. Let's see. Let me get into 1 second. All right, so talk about fiduciary customers are like a trust account. In a trust, a trustee is appointed to manage the assets for a beneficiary under the terms set forth in the trust agreement. The terminology associated with trust is legalistic. Basically, it's legal. The settler is the individual who establishes the trust, donates the assets to the trust, sets the objectives of the trust, names the beneficiary or beneficiaries of the trust, and names the trustee. The trustee is a fiduciary that manages the assets of the trust in the best interest of the beneficiary. So if you're going to appoint somebody to be a trustee, uh, you better trust them for one, and for two, they can only go by what the document says for the trust. So, all right, next is the beneficiary, the individual or individuals named in the trust document for whom the assets are being managed. The trust document may or may not bequeath the assets to the beneficiary or beneficiaries on the death of the settler. All right. So, all right, legal list. The trust is a legal entity formed in the state, with the trustee being a fiduciary over the account. Fiduciaries are often limited by each state in the types of investments that can be made. State law requires that fiduciaries either follow the prudent man rule, or restrict investments to a legal list provided by the state. Under the prudent man rule, only investments that would be made by a prudent individual are permitted. If the state restricts investments to its legal list, then the only securities on the list are available for investment. Generally, legal list investments consist of debt rated in the top four rating categories. You know, that's your Standard and Poor's, Moody and Fitch, uh, credit rating instruments of BBB or better. A copy of the trust agreement must be obtained to open the account. The agreement will specify the types of transactions that the trustee is allowed to perform. So this is laying it all out, what you need basically to set up a trust account. And like I said, this is all paperwork. This is documented. There's no debates. There's no drama, you know, and you can't debate what's on the trust document. And the people that are put in place will protect that. So, all right. Inter vivos trust, testamentary trust. Trust can be set up during one's lifetime, called an inter vivos trust, which is Latin for during one's life, or can be established in one's will upon death, called a testamentary. Um, Inter vivos trust can be set up either as revocable or non-revocable trusts, whereas testamentary trusts are non-revocable, meaning you can't touch it anymore. And we're gonna go into that right now. So, revocable trust taxation, non-revocable trust taxation. In a revocable trust, the grantor remains control over the property by reserving the right to revoke the trust. The view of the IRS is that since the individual grantor retains control, the income in the trust is the same as income to that individual, taxed at personal income tax rates to that individual. On the other hand, income in a non-revocable trust is taxed at trust rates to the trust itself. A separate trust tax return is filed. Okay, so now we got trust for married couples, bypass trust. A bypass trust, also called an A/B trust, is only available to married couples. The intention is to minimize estate taxes. When one spouse dies, the estate's assets are split into two separate trusts. The A trust contains the surviving spouse's assets, which he or she can do with as they wish. Estate tax is deferred on this until the death of the surviving spouse. The B trust contains the decedent's asset and the amount of the estate tax exemption. Thus, there is no estate tax due on the B trust assets. The B trust assets are typically used for the benefit of the surviving spouse, and when he or she dies, the B trust assets are distributed to a named beneficiary or beneficiaries. All right, so trust for second marriages. A Q-tip trust is a qualified terminable interest property trust. It allows the grantor to provide for the surviving spouse and to also determine how the assets are distributed after the surviving spouse dies. Commonly used in second marriages, this is an irrevocable trust. The surviving spouse receives the income from the trust, and upon his or her death, the remaining assets are distributed to the named beneficiaries of the trust, which will be the children from both now dead parents. All right. All right, so now we have charitable trust. If an individual wants to donate funds to a charity and still maintain control over the assets, he or she can establish a charitable trust. The grantor of a trust can be the trustee, and the trustee gets to make all of the decisions regarding the actions of the trust. The donor gets the tax benefit of a charitable deduction with the amount of dependents or with the amount of dependent of the type of charitable trust that is set up. The trust has a fixed life, either a fixed number of years specified in the trust document, or often the trust ends when the grantor dies and assets are distributed to the named beneficiaries. There are two main types of charitable trust, either a charitable lead trust or a charitable remainder trust. The charitable lead trust In a charitable lead trust, the donor retains control of the contributed assets and gets a tax deduction for contributions made to a specified charity with any income from those assets. These deductible contributions are made over a set number of years or are made until the grantor dies. When the trust expires, the remaining assets go to a party of the donor's choosing, usually family members. Next is charitable remainder trust. A charitable remainder trust is often viewed as the opposite of a charitable lead trust. In a charitable remainder trust, the annual income from the trust goes to a designated beneficiary or beneficiaries, such as children of the grantor, so there is no tax deduction for these. And then upon death of the grantor, the remainder is given to a charity. In such a trust, the tax deduction is lower because it is based on the expected present value of the remainder that will go to charity at determination of the trust. All right. So those are your charitable trusts. Um, sure that can be beneficial to some as well, but it's just good knowing this information, knowing what is out there and what you can take advantage of. And like I said, this is really just for the knowledge. And, if it applies to you, great. But it's definitely good to have this information. Um, all right, next we have something called a donor advised fund, or DAF. A DAF, or donor advised fund, allows investors to donate directly to a charitable fund but retain control over their assets. Donors get an immediate tax deduction for amounts contributed, but contributions are irrevocable. The donor decides when and how much to contribute from the fund to various charities. Any assets not donated grow tax free, and the donor decides how they should invest in. I think this is something you wanted to hear about, Mo, if I'm not mistaken. Um, DAF DAF administrators qualify as public charities under Section 501c3 of the tax code. The community foundations or religious organizations can administer DAFs. Nonprofit organizations associated with financial institutions such as Schwab, Fidelity, and Vanguard also administer them. Aside from the fees charged by the underlying investments, e.g., operating expenses for mutual funds and ETFs, there is an additional layer of administrative fees that the broker imposes. DAFs can be set up with small dollar amounts, often as little as $5,000. All right, foundations, very wealthy individuals and families, instead of setting up a trust, often set up a charitable foundation. I think a lot of us know that. We've seen it before. We heard it before. Companies do it all the time. Um, the amounts donated into the foundation qualify for a charitable deduction. Unlike a trust, a foundation has an indefinite life. It goes on until all of its assets are distributed, and this could be more than 100 years. Think of the Ford Foundation, or think about how long the Bill and Melinda Gates Foundation might last with assets over $50 billion. Unlike a trust that can only accept a donation from the settlor or grantor, a foundation can accept donations from multiple sources, such as multiple family members. A board of trustees determines which charitable organizations receive contributions from the foundation, and family members can be on the board. So the family members can exert some influence, but they do not have total control. All right. An estate account. The goal of the executor of an estate account is to perform an orderly distribution of estate assets to beneficiaries after paying all liabilities of the estate. During the time period that this takes, which can be years, the executor must strive to earn a reasonable return on the estate's assets. The paperwork needed to open such an account, such the paperwork needed to open such as an account is a certified copy of the death certificate, copy of the last will and testament, and inheritance tax waivers. All right. That is all for this right here. All right. So now that was actually good to end on, because now I'm gonna go into estate planning real quick. Give me 1 second. Yep. All right. Good. All right. So I'm gonna read 2 articles on estate planning, and then we can go from there. All right. Estate planning 101. What is estate planning? Um, Estate planning involves setting up a plan that establishes who will eventually receive your assets. It also makes known how you want your affairs to be handled in the event you are unable to handle them. Hold on, Mo. What's going on? All right, let me start that over. Estate planning involves setting up a plan that establishes who will eventually receive your assets. It also makes known how you want your affairs to be handled in the event you are unable to handle them on your own for any reason. It's a complicated process, and it can definitely feel overwhelming. There are many components to estate planning, and while there's a common misconception that it's just about your finances. The truth is, there's a lot more to it. There's no denying that estate planning seems like a daunting chore, but it's something we all need to face. We've broken the process down into easy to understand sections. Following our estate planning one-on-one guide will give you the security that comes with knowing you plan for the future of your loved ones. Um, okay. And he goes into what is estate planning. Estate planning is simply the process of making it clearly known how you want your estate to be handled after you pass, or if you're incapacitated and unable to handle things on your own. The most common estate planning definition is the process of making plans for the management and transfer of your estate after your death using a will, trust, insurance policies, and or other devices. Estate planning has been around for many years, but it's becoming increasingly more and more common. There are many parts of estate planning, but the first thing you must do is conduct a comprehensive review of your estate assets. Your estate is made up of all the property you own, including cash, cars, clothes, jewelry, houses, investments, savings, retirement accounts, land, and more. After you have a clear idea of what your estate is made up of, you can then begin planning. Basic basics of estate planning. Estate planning is important for many reasons. Perhaps the biggest benefit is if you don't properly prepare for what should happen in the future. While you're sound and capable, you'll have no say in how your estate is handled or what your loved ones receive when that time comes. Planning today ensures your tomorrow is exactly as you envision it. A properly prepared estate plan will lay out your wishes exactly in the most tax advantage manner so you can trust there won't be any questions, misunderstandings, or misconceptions about what you want. Okay, let's see. All right. Most common most common estate planning documents. Several documents will make up your estate plan. Each is important in its own way, and together they form a powerful representation of your final wishes. Guardianship states want you to have states what you want to have happen and who you want to care for your children or any other dependent you're responsible for after your death or in the event you're no longer able to care for them. Most often, instructions for a guardianship will be included in a section of your will. Will, a legal document that expresses your last wishes for distribution of your property or other assets. Trust, a legal three-party fiduciary agreement that allows the first party, the settlor, also may be referenced as trustor or grantor, to give the second party, the trustee, rights to hold assets and property on behalf of and for the benefit of the third party, the beneficiary. Financial power of attorney, a legal document that gives someone the power to handle your financial affairs. Durable power of attorney, a variation of a financial power of attorney, which is a document that gives legal rights to another person so they can handle any of your non health or non medical affairs. Durable simply means that even if you become incapacitated, the power of attorney remains in effect. Okay. Advanced healthcare directive, also sometimes referred to as a living will or a medical power of attorney. An advanced healthcare directive directly states what, if any, medical action should be taken if you become incapacitated and unable to make your own decisions. Note, it's important to understand that while the terms living will, medical power of attorney, and AHCD, which is Advanced Healthcare Directive, are commonly used interchangeably, there are legal distinctions between them. A living will lets you specify your medical preferences, typically for end of life decisions like life support. A medical power of attorney lets you designate someone else to make healthcare decisions for you if you are unable to do so. An advanced healthcare directive, one second, combines the living will and medical power of attorney to let you give instructions, but also designate someone else to make decisions for you if needed. All right, HIPAA authorization, consent you give that allows your medical records or information to be shared with the third party. Estate planning and taxes. Much of your estate planning is done with taxes in mind. The ultimate goal is to leave the absolute most you can to your heirs. Strategizing by taking action to minimize assets lost to taxes is an effective way to achieve your goal. There are some tools you can use within your estate plan, including ways to avoid probate and past assets while avoiding hefty taxes. Understanding potential types of taxes is important. Estate tax, a tax imposed on estates worth more than a set value. The tax is only assessed on the amount that exceeds the maximum, not the entire value of the estate. Inheritance tax, a tax paid by someone who inherits either property or money from someone who has died. Gift tax, a tax that's applied on gifts exceeding a certain dollar amount. Note, the giver, not the receiver, is responsible for any tax. Who needs an estate plan? Short answer, everyone. It's easy to try and convince ourselves that we don't need an estate plan, but the reality is we would all be better off if we were planning a little more for our future. You don't need to be wealthy or elderly or even have a specific amount in your bank account to justify the need for a valid estate plan. If you are over the age of 18, you should start thinking about creating a plan. Even if you don't have a lot of assets, your estate plan is a guarantee that everyone will know what your wishes are. Health directives and long term healthcare wishes are perfect examples of this. If you were to ever become incapacitated and could make your wishes known, your estate plan will speak for you so your loved ones don't have to make unthinkable decisions or wonder what you would want. It used to be that properly preparing these types of documents that go in an estate plan could cost you thousands. But now you have options. You can get an affordable, legal, effective, valid estate plan that ensures your wishes will be known should the time ever come as needed. Even if you don't have a lot of assets, an estate plan is still a wise idea. All right. How to create an estate plan in 12 steps. Yes, there are a lot of steps that go into creating a complete estate plan, but we made it as easy as possible for you by listing each out. One, gather your assets, inventory everything you own from cars to collectibles. Two, protect your family. Think about if you have adequate life insurance to leave your family in a position where they can maintain the life you currently lead. Three, determine the plan that's best for you. Decide what type of estate plan you need. Four, choose who you would like to be guardian of your children, pets, or self. If you have children or pets, or if you care for another loved one who cannot care for themselves, you want to choose a guardian. You can also name the person you will want to make medical and or financial decisions on your behalf should you ever become unable to do so for yourself. Five, determine and establish the necessary directives. There are several directives you should include in your estate plan, including but not limited to durable power of attorney, medical care directive, limited power of attorney. Uh, LPOAs are less commonly used. Durable power of attorneys are more frequently the norm. Through an LPOA can be appropriate in some instances. Six, name your beneficiaries. Some documents and accounts will have beneficiaries already designated. These could include retirement plans and life insurance policies, to name a few. But there are other assets you should note in your will or trust if you'd like to leave them to a specific person. If there's an opportunity, you should name contingent beneficiaries. Keep in mind that beneficiary designations will only go into effect after you pass. So if you become incapacitated and unable to make decisions, you need to have prepared for more. You need to have prepared for more than simply naming beneficiaries. 7, finding a trusted partner. Explore your options for creating your estate plan. This can be face to face with an attorney, or you may choose to use another service provider. You have options, but some are going to be much more expensive than others. If you don't have an overly complicated estate, working with a partner like Trust and Will would be the perfect solution to starting on the path of estate planning. 8, create your plan. If you're using an online program to create your estate plan, be sure to go through all the steps and finalize everything. 9, sign and notarize your estate plan. Don't forget to check how many witnesses your state requires. 10, notify your executor. It's a good idea to let the person you chose to be your executor know of your intentions. 11, store your estate planning documents. Put your estate plan in a safe place where your loved ones can easily find it. A fireproof safe is a good idea. 12, update is needed over time. There isn't a hard rule about when you should update your estate plan, but a good rule of thumb is to try to update it whenever you have a major life event, birth of a child, death of someone important to your plan, marriage, divorce, and so on. And if you find you haven't had any life events in recent years, try to review and update as needed every 3 to 5 years. All right. Common estate planning mistakes to avoid. Take caution when developing your estate plan. There are many mistakes that could result in delays, inaccuracies, or other misunderstandings. Some of the common mistakes people make along the way include not having an official plan, not updating a plan over time at major lifetime events, not making arrangements for if they become incapacitated, disability, or long-term care, improper ownership of assets. How easy will it be to pass assets on? Not including charitable gifts, not appointing a guardian for children or others who would need their care, underestimating the implication of taxes, not having liquidity of assets, not making gifts during their lifetime to reduce the value of the estate after passing, tax advantages, putting their child's name on the deed to property, potentially huge tax implications. All right. A difference between an estate plan and a will. While many people think simply having a will is sufficient, the fact is you need more. If you have a will, you're off to a great start. But a will by itself is just a small piece of the estate planning puzzle. In order to fully protect your loved ones after you pass, you must incorporate all the documents, nominations, and appointments to ensure you've done everything you can to make the process easier on them when the time comes. Other common questions about estate planning. What are beneficiary designations? A beneficiary designation is a way to designate where your assets go after you pass. What does a trustee do? A trustee handles and is responsible for managing all assets or property in a trust. In essence, he or she is the legal owner of said assets. How much does an estate plan cost? The cost of creating an estate plan can widely vary depending on a number of factors. If you go the traditional route and work face to face with an attorney, your costs will be much higher. Newer methods of estate planning include innovative and creative platforms like Trust and Will, where you can get a legal estate plan at a fraction of the cost. Do you need an attorney to create an estate plan? In some cases, you do not need an attorney to create your estate plan. If you have a very complicated estate, you may opt to go the traditional face to face route. but many people have simple, straightforward needs. They may find a service like Trust and Will is ideal for their estate planning needs. It can save time and money while still offering a superior product that touches on all the important things you want to take care of with your estate plan. Though there are many parts to a complete estate plan, tackling them one at a time is the best way to draft a plan that's conclusive, comprehensive, thorough, and that protects everyone in your life you love. All right. That is estate planning. Definitely a lot of information there. Um, this other one, I have other article. I don't think I need to read that. That's pretty much the same thing. Just discussing, estate planning, why it's important, the purpose and the documents needed for it. Talking about your will and testament, the trust and power of attorney and all of that stuff. So, um, pretty much the same thing. But yeah, man, this stuff is important. I definitely want to go over this and share this information about you know uh
All right, Chris, I'm tuned in.
huh
I said I'm tuned in.
okay. Well, no, I just went over like
I heard you.
oh, you did. Okay, so there was a part in there I was discussing you know what remember you was talking about you know bit business income, what you could put your business money in and
Yeah.
all of that. So I don't know if you caught it, but the DAF is probably something you could use.
What's DAF?
Yeah, it's a donor advised fund, basically.
Oh, yeah, 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 yeah. I caught that the last time when we did it the other day.
Oh, you did?
Yeah, when you was going over the stuff. Remember, I was looking it up as you went.
Uh-huh. Okay. And then they have different kind of charitable trusts too. So those are recommendations or vehicles that people park their money in. When it comes to their tax and their tax money, not paying taxes. They do this a lot. So it's just how you do it. But you really can't do it illegally, but you can do it legally if you know what to put it in. So, and it's dark as hell in my room. But so we went over that. We talked about the different type of trusts, the different accounts that people can have. Of course, you can have an individual account. You can have a joint account with rights of survivorship, tenant by entireties, and tenants of common. So they basically they have multiple people. One specifically for couples or marriages, people who are married, business partners, which is the tenants in common, and the just the regular joint account with rights to survivorship. Like I said, that could be family oriented, be boyfriend, girlfriend, could be husband and wife, be your cousin, your uncle, whatever the case is. But it those accounts are to bind y'all the people together, and there's certain rules and regulations on how, if let's say somebody was suing you, you know in certain accounts, they could take 50% if that was the case of that account, just because of how the account you have. And then
Right.
there's some there where they will tax just you, the person, as a single entity when there's multiple entities on that account. So, and then we went into estate planning and trust and wills, having a power of attorney, irrevocable trust, revocable trust. I just read about that. So people can, really understand, need these type of accounts to, keep your legacy alive if you care about legacy. And I think Black people need to care about their legacy.